Hello, Peter. How are you?
I'm very well, thanks. Thanks for having me.
Well, it's very nice to meet you. I've seen you a lot on social media. I never actually got to meet you in person yet.
No, this is the
Hopefully,
first time, yeah.
yes. So I'm very happy to meet you finally virtually, and hopefully soon it will be in person. But I see you a lot on social media. You're very active. And one of the nice things about you is that you actually contribute a lot to the profession through your work as a lawyer and as an academic, but also in education. And so we want to talk a little bit about that today, what you do, how you're contributing your opinion about what's going on in the profession right now, and also a very specific area of law that I see you're very active and you're very always writing about, and that is the area of sex assaults. So let's just
Sure.
start with what you do, Peter.
I am really busy always. So I've been a law professor for 25 years.
Mhm.
I started out in New Zealand. I was a professor there, and then I've come over, and I'm still a full-time faculty member at the University of Alberta. Thankfully, I'm on sabbatical, so that's great. But since 2017, I've been litigating cases. I've litigated more than 50 appeals, some trials, a variety of things. Like I have a full-time litigation practice called Sankoff Criminal Law. And I also am the founder and CEO of Criminal Defense Essentials, which is an educational platform and hopefully more than that for defense lawyers across Canada. So I've got three things that occupy my time. I am winding down my career as an academic because I've been doing that for a very long time. I don't have a specific end date in mind, but as I said, I've been doing that for 25 years and I've been litigating for eight. And in 2022, I started my own firm. So yeah, it's always busy here. There's never a shortage of things to do, and yeah, so that's sort of what I do in a
Well, let me
nutshell.
start with I think the question that most people will have is, well, then how do you manage all of that when I know you said that you're winding up your academic career now, so that will give you more time to focus on the other things that you're doing. But so far, how have you been managing?
So I get that question a lot, like
Mhm.
how do I manage to do it all? So first of all, let me throw a lot of credit to my staff. Like the important thing about CDE was, which is Criminal Defense Essentials, was it was really critical to monetize it because that was the only way I could keep it going. So CDE was born out of the pandemic. I started doing seminars that were very popular on Zoom because everybody was at home, and those were all for charity for the first 3 or 4 months. And then I realized that we might have something there, and I had a pretty loyal following. So we decided to create what was at the time was called Professor Sankoff Seminars. And I did that for a year or two. We made money, but really, like just money, like not a
Mhm.
lot of money. And I was able to slowly start to bring people in to assist with the work. So essentially, one of the ways I'm able to do what I do is because I have a staff that I'm able to fund through CDE and my law firm, and that's a big part of it. How do I do the rest? Aside from, I think I'm really lucky. I process things fast. As a law professor, I've been doing analysis of concepts for so long that let's just say that I have a bigger framework to fit everything
Yeah.
into. And because of that, it makes some of this easier for me. I've also learned how to duplicate things that I'm doing. So like for CDE, we really do go through all the cases and try and assess them, and I have staff for that, and they then curate them for me. Like I used to do all that myself.
Yeah.
Like I used to literally go through all the cases and find the ones that mattered. Now I have staff to do that, and they curate it down to the ones they think are the most significant. and then I flip through them and figure out which ones I want to focus on for that week. So because I have staff that are able to put it together, it does cut down a lot of the time. And then what I do is like all of this research I use for other things. So like I fit the research I'm doing into my cases,
Hmm.
and I also fit the research I'm doing into my books that I write. And as a result, like there's a lot of cross-pollination, and I find that that's the best way for me to proceed both as an academic and as a lawyer. Like there's a reason why I'm advancing all these cutting-edge theories in court. It's because I think about them as an academic. I am constantly researching them through my staff and myself. So I actually think it's a really good
Yeah.
combination of things.
Yeah.
And when I do things like I lecture and I record them on Zoom, like I use very similar techniques for each of the areas that I work in. So as a result, like yes, it's a lot, and I'm constantly reminded that I work too much, and that's a problem. But aside from that, I'm able to use things for multiple platforms.
And you're also offering to the public as well some of that. I mean, like through CDE, like it's you're not keeping your knowledge to yourself, you're actually sharing it with others, which actually is very important right now in the criminal defense bar because we do
Mhm.
have almost like a crisis. We have a lot of people who are leaving, and true money is one of the problems. But another problem is, I think, a lack of mentorship. People are not, they don't know how to learn and where to get models and examples. So maybe we can talk a little bit about that. What is your observation about this,
Sure.
Peter?
I mean, I started CDE because that was my observation. Like the whole basis for starting Criminal Defense Essentials and putting together products that could make the job easier
Yeah.
was one of the reasons I started this company. I'm firmly of the view that there's too much siloing and duplication of effort. It's just the reality. Criminal defense lawyers, we are in a tough battle against the Crown in any case that we fight. And one of the reasons for that is that the Crown has a centralized network. There only is one Crown. So as a result, I mean, different provinces, but when we're facing the Crown, we're facing their resources as much as
Mhm.
anything else. And for some reason, defense lawyers have stuck to the idea that we all should reinvent the wheel. And what I mean by that is it's a very difficult process to constantly reinvent the wheel. And part of that stems from this concern about proprietary knowledge. It is true that if I spend a lot of money and effort putting a factum together, I'm going to be somewhat reluctant to just give it to somebody else to use and make money off of, because that's what some people will do. And I think what I wanted to do with Criminal Defense Essentials was put together resources that would get us closer to an equal playing field with the Crown. So, like each of the things that we do at CDE are designed to help you right now, mostly with legal stuff, so that if you're facing whatever, a 276 application, you have easy access to all the latest cases, all the developments, all the trends. But I mean, eventually, the goal is to provide better resources that will essentially provide frameworks for, as you point out, how to do and how to argue all these particular things. The,
Yeah.
the difficulty for the defense bar is that it has never had that sort of incentive to develop in the same way as the Crown has. The Crown has real incentive towards profit maximization, as crazy as that sounds, because they're a government entity, but they really do have a lot of incentive to centralize and come up with things that can be used across a range of proceedings. Defense lawyers have never had that incentive because we are all hundreds of individual enterprises. And as a result, like there is a competition type of setting that gets put up against each other. And as a result, like it's a lot harder, as you point out, to get the mentorship and the leadership that you need in a way that is both cost effective and prompt. And, when you bring up the issue of mentorship, like, I'm not going to tell you I have a full mentorship role, but there has been a crazy market for my services to assist people when they're trying to do things at an early stage. So, like, this is my law firm. This is not CDE, but like, I am retained by lawyers a lot because they don't have easy access to stuff and they can call me and I can give them answers. And, I've been criticized for that in the past, in a sense, by saying, well, we're all lawyers, we're collegial, we should do that for free. But the truth of the matter is, like anything else, you get what you pay for. I can do free advice to people, but it's going to be a hell of a lot more limited because I don't have the time to be assisting you. When I'm talking that I'm a consult, like I will look at the problem when you send it to me. That's what it is, right? And I think that sort of idea of trying to create support services for defense lawyers is one way of sort of getting us out of the mess that we're in. I don't think it's the only answer. I think there are other concerns we're going to have to address at some point. But I do think that trying to find ways to create support structures for defense lawyers is just such an important part of the equation. Yeah.
Yes, and I mean, it is also this concept of competition that we have on the defense side that maybe is less present on the Crown side. I mean, the Crown does seem to be operating as one office. I mean, we have several Crown offices in different regions, but ultimately they all have the same global goal, and they're all working towards the same goal. Defense there is this business aspect to each firm, and then there is the defense in general. But I mean, I find it it's a little bit contradictory though, because us as defense lawyers, our job is to defend rights, human rights, and we're the ones who are advocating for fairness, for protection of the constitutional rights and charter rights of individuals. And yet there is also this business aspect where people are trying to profit, and there are some people who are more business oriented than maybe charter rights oriented. So I don't know, it's a little bit of a dilemma that I find, and I think there should be a bit of a balance where we still remember that our job is also as defense lawyers is to protect rights, and this is what we advocate for. And so sometimes we can do things for free or at a lower cost just to help the defense bar in general. Like this is what I find frustrating is sometimes we forget the bar in general. We're each working individually, but forgetting our role as a collective. And yeah,
Yeah, I
I
have
mean,
some thoughts on that. I mean, I actually think on an individual basis for an individual client, the defense bar does its role quite well in the sense that if I have a client who's facing a problem, I'm not going to lie, everybody goes through this. Like there are financial issues. I can want to defend a client from here till there and give them everything they want. But at the end of the day, I have a business to run, and my business isn't going to run well if I'm doing free work for everyone who
right.
walks in the door. That's a balance for everyone to figure out.
Yeah,
I do pro bono work. I'm sure you do pro bono
yeah,
work. I do reduced fee work.
yeah,
I do less legal aid work, but that's a frustration I have with Alberta legal aid and the reality that I'm just really busy. But
yeah.
nonetheless, on an individual level, I'd like to think we do pretty well. Where we fail is on a
Hmm.
collective level.
Yeah.
And the reason it's classic tragedy of the commons type stuff. There's a joint interest in a lot of us doing X to make it better for all of us.
Hmm.
But how do we go about doing that? And who's going to take the lead and sacrifice to do that?
Yeah.
It's the same thing as always. There are a lot, I could list for you 50 initiatives that I think would be really useful for the defense bar to push. But like, who's going to do that? Who's going to champion that structure? As you point out, one of the dilemmas you're very correct to point this out, is that we are the ones who are said to be speaking for the voices of
The
present and
oppressed.
future
Yeah.
criminal
Yeah.
defendants.
And
We have
yeah.
this critical role to play in a constitutional democracy,
Hmm.
especially as more and more policy work, as I like to put it, is fed through the charter. And
Hmm.
this question of like how we do things as a collective is really difficult to figure out. And I'll just give you a good example. This is my favorite example of the difference between the Crown and the defense. Okay. In a nutshell,
Yeah.
if you look at this, everybody always says like Crown appeals have a higher success rate, right? and Crown leave to appeal have a higher success rate. And I promise you, this is not because the Crowns are such superior lawyers and they're such, amazing talents. What they have the advantage of is selectivity in the public
Mm-hmm.
interest. And that is such a big factor.
Yeah.
So, I have said in my CDE materials over and over again, I'm like, well, we have a bad facts case here. Bad facts, hard law. Every once in a while, that bad facts is against the Crown. You have a bad police misconduct, the Crown somehow wins it, you get to appeal, and it looks bad, and you can get a good result. But those are rare. Most of the time, we're the ones with bad facts, and we
Yeah.
have some law in our favor, but we are trying to advance the bad facts case up. And me, just looking at this in the complete abstract, and I know what I'm about to say is completely unrealistic. I look at these cases that go up and I'm like, don't appeal that. You're never going to win. We're going to entrench a terrible precedent. The facts are horrendous. We don't want to go that way. But of course, that's not how the defense bar works, nor necessarily should it work that way. But it is a reality that you have to factor in when you're trying to look at why the defense bar is so different from the Crown in that sense in advancing a public good. And the reason is we're not really supposed to be advancing a public good, but yet we are. And that
Yeah.
is the
Yeah.
difficulty, getting that collective will together. When it happens, it's a beautiful thing to see, but it's very difficult to do because it's not really our job. It's not really our job, even though we've been assigned that job of protecting the broader public interest. And that has never been more true than when you're dealing with the Charter of Rights and Freedoms and we're tasked with advancing rights-based arguments.
So, I mean, I don't know what to say, honestly. Like, I just hope that we will get to a point, though, where we can do something on a collective level. Because honestly, I mean, there are some cases, especially that we see at the Supreme Court level, where there are lots of defense lawyers involved. And it's really nice when we see that we're all getting together, advocating for the same legal argument. And I find like it adds so much strength to the argument when we're all unified and we're all trying our best in our different ways to advocate for that point. So I really wish that there was more unity in the defense bar.
It's so hard, and I don't think it's just a question of unity. I can give you another example where like I have had cases where I've got a great case. I've got a great case, but the client doesn't have money and the
Yeah.
client can't run it the way they'd
Hmm.
like to run it, or they just say, screw it. I'll give you an actual real example, but I can't name the case. But
Yes.
there's this case out of Ontario and it comes down, and the ruling is horrendous. It's really problematic. And I speak to counsel, and I'm like, look, this decision is going to screw us for the next 10 years. Like, we've got to seek leave to appeal and get this tested because it's wrong. And at the end of the day, the client just didn't want to proceed. And like, in that case, I think if we had said to the client, it won't cost you anything, then the client might have done it. And I suppose at the time I had no capacity for pro bono stuff. But like, ideally, there would be some sort of funding agency for the right
Hmm.
types of
Yeah.
cases. Because what worries me is that, this idea of defending individuals has worked for a long time, but the more that we start to see bigger decisions happening, it just gets harder for individuals to do that sort of work and bear the personal and professional cost of doing it.
And that's the thing, like when there is law, the law applies to all of us. So all of us as defense lawyers will have to deal with the law. And actually, there's no better area to describe that than the sex assault area, which is really right now getting from bad to worse when it comes to the defense. So if we all work together to really push back and make sure that it becomes like more like that it makes more sense. My frustration right now with this area of the law is I find it makes really no sense. It's also creating this kind of difference between even between complainants. Like it seems like complainants in the sex assault area have more advantages and privileges that are not given to other complainants in other areas. And I don't know why we decided that, or not us, but why Parliament decided to give them some privileges, not others. It's just a very messy area of the law. And I feel like if we were, as a collective defense bar, working more together to push back against that, we I mean, I wonder if we would have even gotten to the point where we are right now in sex assault. So I would like to hear from you because I know that you are very active and you write a lot about this area in particular.
Yeah, so I mean, I wish I had easy answers for you. I can tell you that the defense bar has fought on occasion. I was part of, the group of lawyers and legal organizations that fought against JJ and the
Yeah.
278.92 materials.
Hmm.
I was one of the interveners in that case, and like there was a lot of work that went in jointly on that particular effort. But um, I I think it's again, there are difficulties to doing it, but I do share your point that this is an area that is of great concern, and
Hmm.
that's why I've made it such a focus of what I'm doing to try and speak out because it's difficult, number one, to speak out on this issue. There are a lot of people who are you're gonna face a lot of flack when you speak out on this issue and make people aware of what's going on and how far a deviation from the norm we've sort of gotten.
Yeah.
One of the problems is it's very difficult to keep fighting against it when the courts seem to embrace this difference
Hmm.
and accept it and entrench it. Now,
Yeah.
that's not exactly what's happening. And you're correct that as a collective, we have a role to constantly point out problems in this area that are both leading to wrongful convictions and causing chaos in the courts. I mean, I have a talk coming out next month. I'm doing it for CDE. It's going to be recorded and then it's going to be made public for free. It will go beyond because I've given this talk already about 10 times to judges, defense bars, etc. And it's trying to show how far off the norm we've gone,
Yeah.
just to sort of compare and contrast and sort of show where the difficulties lie. I'm just going to say this. One of the problems in this area is that the law has gotten so complex and convoluted that it's not even easy for defense lawyers to know
Yeah.
what it is.
Yeah.
It's
I
and
agree.
let alone defense lawyers, crowns or judges. So to me, this is an area in which problematic decisions are rampant, and that's not the fault of the judges deciding them. I mean, part of the problem is that the law has gotten so counterintuitive that we can no longer apply rational norms of evidence
Yeah.
law to this problem. I call it actually, I've referred to it openly as what I call the sexual assault vortex or the sexual assault black hole. And the reason I call it that is not to show that it's a black hole like it's the worst place. No, no, it's just that the rules of ordinary light and physics don't work in a black hole. And that is starting to be how we're looking at the laws of evidence and procedure in sexual assault cases. The truth of the matter is, basic bedrock concepts of criminal law and evidence, the need for mens rea, the basic idea that relevant evidence should be admissible. These basic principles have just been really I don't want to say ignored or set aside. That's not right, but they've been altered in
Yeah.
sexual assault
Yeah.
trials. And because of that, we're still struggling to deal with the fallout of it because I don't believe anything about the way we deal with these proceedings is intuitive. I think that every aspect of them are debated on a regular basis. I read the case law and I can tell you that nobody really understands every aspect of it, even me,
Yeah.
because what I'm telling you is a lot of the basic principles that animate this jurisprudence no longer make that much sense
Yeah.
or are so inconsistent with the way we deal with things in other areas that we've started to accept them
Well,
as just
and
a
one
deviation.
thing is Jordan, is how do you reconcile this with Jordan, this demands from courts that we need to do things as quickly as possible because we don't want delays, and yet we keep getting all these pre-trial applications that we have to do, whether it's the ones that are for the defense, the JJ ones and other ones. And now also we have this case of Kinnamore as well. So even the Crown now has to bring these applications. So, I mean, with all these pre-trial applications that we need to bring specifically in this area, and how do we do this with and comply with the 11B timelines? It's just
I
chaotic.
don't think it's possible. I mean, my thesis that I'm working on for my presentation is that it's impossible. You cannot continually impose a broader scope and the need for detailed written applications, two-stage proceedings that have to be separated. The Crown cannot consent. They have to be vetted before the judge. You've got to
Mhm.
bring in complainants counsel. You know, when this happened, I said immediately, like, they're going to be, as soon as JJ was decided, I say, well, like, the first thing I'm going to do is raise my rates for sexual assault
Yeah.
cases. And that's just a defensive measure. It's not because I'm trying to get greedy on this. It's just because I could see what was
Yeah.
coming. And raising rates is not a solution. There's still going to be, you know, that the what I call the unexpected 278.92 or 276 applications are just unbelievably common. And the architecture that's sprung up around these sorts of applications is, again, you have to understand, first of all, they're substantively difficult. They're actually,
Yeah.
it's not always clear when this evidence is admissible. And the need to consistently fight over it at the vetting stage, as you point out, is lengthening trials. And there is no answer in sight, which is why I have consistently argued to defense lawyers in every talk I've done. If you want to win over the trial judge, speak the efficiency language. You can speak unfairness all day. That ship has kind of sailed. It's not that I don't think it's unfair, I do. But when I talk about this stuff, the way I talk about it is we've created chaos. And I think that message is resonating. And as you point out, you know, the first paragraph of the Kinnamore decision at least seems to acknowledge that we're in a crisis.
Yeah.
And I think that is a step forward. Like I've been making the rounds doing a talk on sexual assault everybody loses. I think the first one I did was 2 years ago or 18 months ago. I'm not sure about it. And I was constantly opening with like a Titanic metaphor and how we're just trying to fix the draperies on the Titanic. But the
Yeah.
truth of the matter is, Kinnemore is eye-opening to me, not so much of what it says about the crown and stuff like that, having to go through vetting applications, but more about it's really the first stage of recognition from the Supreme Court, at least, that we can't go on that way. We've heard it from provincial court judges, we've heard it from lower court judges, but at some point, the appellate court judges are going to have to get into this and say, look, this cannot go on. It's just it is it is causing such disrepute to the administration of justice. It's crazy. And I don't blame it. I'm not a big Jordan guy. Like I'm not a big delay stay. I don't really like it any
Yeah.
more than most
I
people,
agree.
members of the public do.
Yeah. I'm the
But
same.
that said, the Crown is trying to fight this by pushing back on Jordan and getting Jordan limits out and doing all that.
Yeah.
And I'm like, I don't think that's the answer. How about you clean up your house? You can't take this house and throw all this stuff in it and
Yeah.
then say there's no room in the house, so we need
Yeah.
a bigger house. I'm like, how about you get rid of some stuff
Yeah.
and then we'll see how we go.
Well, I mean, that, to me, honestly, what I find is an advantage, maybe in this case, is that it will force the Crown to really think about the case. Do they really want to get into this? Because now they have to bring applications. They can't just use them, just like with the defense. Well, now they have to consider, do we really want to bring it and waste that much time and get into this? And maybe, like I don't know. Hopefully, maybe they will offer some deals in some cases or they will reconsider, but it will force them to think about this because until now, they seem to be just doing whatever they wanted to. And it was all on us. We were the ones who had to bring applications if we wanted to use something in these cases. So now it's like forcing the crowns for once now to really sit and think and consider each and every case, because that's another problem that I've been experiencing, at least in Ontario with crown offices, is that they just prosecute almost everything. Like, okay, well, fine. If you don't want to take this deal, then we'll have a trial when they have the power and the discretion to see right away that some cases are really not worth any trial time. We shouldn't be wasting a half a day or a full day or 2 days on these types of cases. And this should be apparent from the beginning, not on the day of trial to get offered that peace bond. So I
So
don't
it's
know.
really a perfect storm. Again, you're
Yeah.
just talking about a lot of the things that are in my talk, but I'm like, it's a perfect storm. It's an input-output problem. At the
Hmm.
same time as the Supreme Court tried to fix this stuff
Yeah.
post-Meshi, the Parliament and the Supreme Court and whatever, putting more and more restrictions on,
Yeah.
at the same time as Robin Camp was, blowing up all the problems about myths and stereotypes, which again required us to correct a terrible decision, right? Like, I
Hmm.
get it. Like, the problems themselves are real. And the idea that the police weren't taking sexual assault claims seriously, that seems pretty borne out to me by the statistical evidence of how crappy they were. But what's happened is it puts so much under the microscope that we went from here to here on all these points like that, and all those things together. It's not an individual factor. If we just, I identify what I think are the 6 or 7 main pressure points. If we just had one, it would be fine. But
Yeah.
we don't have one. If we
Yeah.
just had
I
more
agree.
input, more cases under the same old rules, no problem. If we had sexual communications count as 276 on its own, no problem. Even 278.92, narrow, narrow, not freaking every text message you ever sent, but
Yeah.
narrow to records. Each of these things individually is not a disaster, but you put them all together and
Yeah.
collectively, it's just, it is to me the biggest criminal justice scandal of our time, in the sense that we are literally sinking, and everybody's just like, okay, well, let's just either keep going or we'll tinker around the edges. I don't think that's going to last. I am convinced that Kinnamore is step one. That first
Hmm.
paragraph is step one. And I have to hope that there's going to be change, because we can't keep going on the way we're
Yeah.
going.
Yeah. I agree. I mean, I really hope so because it is becoming very difficult to practice in this area. And surprisingly, also, we have, I mean, there's more and more of these cases. I mean, there's
Well,
just,
as I said, input output, right?
yeah,
But
I mean,
spare a thought for the trial judges too, right? I educate trial judges, and no one really wants to feel that much sympathy for trial judges. But the truth of the matter is, they're in a terrible spot. They're aware that for the first time ever, the spotlight's on them. And when they make that decision, you know, we say judges are above it all, and a lot of them really are, but like, they're human too. And the last thing they want to get is called Robin Camp. They don't want that. They want to be able to continue living their lives and not be in the paper as the person who applied a rape myth. Rape myth. Those are big words, and the judges, understandably, are taking this seriously. No oral rulings permitted, thanks Parliament. Detailed written reasons that have to go through this. I mean, everything is a perfect storm that is just making it chaotic. And honestly, I feel for just about everyone, because it's gotten away from us, and it needs to be corrected
yeah.
if we're going to have any hope.
Well, okay. So because I like to end on an optimistic note, but are you
Always. Let's go
optimistic? Like, I
optimistic.
mean, we have to be optimistic, right? Because then
Sure.
it's such a depressing thing. So, but is there hope? Do you feel, and I know you, one of the good things that you pointed out to is this first paragraph in Kinamore where the Supreme Court itself recognizes that there is a problem, there is chaos right now in the courts in this area. But beyond that, do you think that there is hope? Do you see any light at the end of the tunnel?
Yeah, so I'm always an optimist. I don't give up until we're beaten completely. I mean, I was pretty depressed from 2022 onwards. I read JJ and I joke about how I needed a scotch for every 5 paragraphs because it was so depressing. But
Yeah.
I do think that I have to believe that the justice system is going to correct. I have to believe that we're seeing enough people talking about it. I'm hearing from reasonable people. Judges are including it in their rulings. And I do think we have to be on a path towards correction. How that correction takes place is an open question. I just know I'm going to play a role in fighting against it. And nobody should ever give up when you're faced with this. We have real clients facing real custody over allegations of this sort, and
Yeah.
I believe it's our obligation to continue fighting and having hope that things will change. I don't think anything is ever, I have enough of a historical sense of the justice system to know that nothing can ever go one way for too long. There just are corrections to the norm. And I think we try to find in Canada an equilibrium that makes some sense. I mean, in my talk, I come up with like 8 basic solutions. They're really simple and they are not designed to correct too strongly one way or another, right? So like for example, I would exempt all sexual communications between the accused and the complainant within a reasonable proximity. I don't really care what the proximity is. If you want to say, for example, that any text communications within 48 hours of the event in question are admissible
Yeah.
unless it would be detrimental to the course of justice or whatever. Like
Yeah.
that's it. They're admissible so long as they're relevant, of course. But if they're relevant, they're admissible. And then over 48 hours, you'd say, okay, well, we still have to vet them. Things like that. These are reasonably easy fixes that really would not gut the regimes. Like obviously, if you ask me what I would do, I would repeal 278.92 or I would limit it to enumerated records only. I would get rid of reasonable expectation of privacy. It's too messy. It requires too many things for the defense to do. It's too confusing. I think these are solutions that are not altogether unreasonable. And the question is just which one are we going to take?
Yeah.
So to me, there are options available that are, kind of middle of the road. I don't know how anyone can look at what we're doing now and think it's great. I don't even think anyone except, you know, the truest of true believer crowns really, and certain victims' rights groups, not even all of them, because like I am not of the view that complainants or victims are thrilled with the status quo either. I don't see how they can be. Everything is magnified. Suddenly these text messages take on a life of their own. And suddenly it's like I don't see how lengthy procedures that wind up in, never-ending proceedings are good for anybody.
Well, and sometimes the victims themselves want these text messages to go in. I mean,
Mm.
it's not just in the accused advantage. Sometimes it's even for the victim. So, I mean, it's just, I think what we want is maybe to go back to how things used to be before. If we can at least go back to the before normal, we're at this point, I think it will be nice to just
I don't
have
know if we ever get back to where we were. Um,
or
as I
close.
said,
Yeah.
I believe that's not going to be given away easily.
Yeah.
But I think a variant of what we had before
Yeah.
these new measures were put in would be sensible. I would like to think that we can recognize like the idea, it's so interesting that the idea of including sexual communication as sexual activity, I swear to God, that went in. And everybody was like, well, the case law had already said it. I'm like, yeah, the pretext case law. Like before text messaging and other forms of chatting became like ubiquitous. And all of a
Yeah.
sudden we realized that, you know what, as it turns out, people like talking about sex in written form
Yeah.
much more than they do in person because
Yeah.
people are shy in person.
It's
So
true.
it's like in the old days, sexual communications were like, oh, they didn't come up very often because they were just things that were said here, there, and everywhere. Text messaging has changed that. Like
It's
it's just
true.
it's crazy how bold people are when they're writing. I
Yeah.
know that
Yeah.
because like, I've read my Twitter feed and people calling me all sorts of names, but it's like boldness comes from, being behind something. And it's like
Right.
nobody ever conceived of that and we didn't really realize what we were getting into. So
Yeah.
these things need to be reconceptualized if we're going to have any hope.
Well, hopefully there will be hope. I really hope that
Hope is
things
good.
will get better. And like you say, I mean, Kinnamore is hopefully one step in the right direction, and we will have more. I mean, I will be happy to have another interview to follow up with you and see how things
Mhm.
go, Peter. But it was really very nice to chat with you and to hear your perspective on criminal defense in general and on this very messy area of sex assaults. And hopefully, we will continue this conversation.
My pleasure. Thanks so much for having me.
Thank you.